All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Leon Baker, Kirkland Huggins, Lisa Peace. Miss Peace is here. Thank you. Matthew Gould. Yeah. Thank you. Sean Davis. Hayden Mitchell. Hayden Robert Mitchell. Zanitra Porter. Andrea Pullings. Andrea Pullings. For the record, CR 2313, Tanya Swart, set for arraignment. Mr. Manning filed a waiver of arraignment. That's approved. Pretrial is set September 21st. Ms. Swart not here, correct? James Young. James Paul Young. Jeremy Estridge. William Petty. William Lynn Petty. Robert Wells. Detriana Baker. Miss Baker. The state, come on up. Your attorney, Mr. White, is across the hall with another client. He's aware, I believe. Yes, sir. The state has filed a motion to dismiss your case. Or granted that this morning. It's free to go. Thank you. Yeah, Grant Gonzalez. He's in the hallway. Thank you. And Mr. Yu. Mr. Yu is across the hallway as Sean. Still on the one call.
Morning, Your Honor.
Good morning, Ms. Shaw. Can you see and hear me okay?
Doing okay, thank you. How are you?
Doing well, doing well. All right, so this morning, was kind of a change of plans, and so what I was going to talk to you about was Mr. Yu is here, and he and his attorney are across the hall, and the attorney was going to ask that you help him explain some legal concepts to his client. So what I was hoping to do was, before we make any kind of board announcement, is that I'd be able to put you in a breakout room with Mr. White and Mr. Yu,
Okay.
so that they can have a discussion and you can assist Mr. Yu.
Sure. So are we going to do that immediately or shall I wait for them?
No, it'll be immediately. So I was just going to let you
Okay.
know. And
Sure.
We're in a breakout room. So just a moment, when you get that,
Okay.
it'll just be you and them in that breakout room.
Copy that. Thank you, Honor.
Just one moment.
Okay.
Okay, Mr. Gould, Matthew Gould. This is cause number CR 2389.
My approach, Your Honor.
Yes, sir. Okay, I need you to do that over there, so he's involved and stays involved. All right, so this hearing is on motion or vote. Go ahead, Mr. Wallace.
It's actually a motion to modify conditions of bond that we filed, Judge, back on May 30th, 2023, specifically asking the court to consider reunifying the immediate family for the defendant with his wife and 3 children. The wife and 3 children live up in Michigan. So that's the issue before the court. We're ready to proceed.
Right, and the state has a copy of this.
Yes, Judge.
I do.
Then you have a position.
Your Honor, state's in agreement with this plan. I spoke with Mr. Lawhorn, earlier today, and I believe we are on the same page, regarding this motion.
That's correct, Your Honor. And if I may, we actually asked for this plan to be to have more of this. One, to have it be put in writing for the court, to give the courts the piece. The wife is taking a chaperone class. She's not done with that quite yet, but she will be done with it in the next couple of weeks. The goal here, Judge, is to have the family reunified by October 1, which would allow us to work this plan that was suggested. I think it's a very comprehensive plan by Dr. Kennedy before the court. Also inclusive in this are going to be some virtual meetings between the wife and the children and the defendant with Dr. Kennedy. That's really more for the benefit of the non-biological children interacting with the defendant under the supervision of Dr. Kennedy's to sort of green light the reunification process. The other conditions that the district attorney had recommended we're in agreement with, which would be, I think we're already standard of his probation. So our hope is that the court sees that we weren't just trying to grab something out of the sky and get a change. We have a legitimate path forward such that the family could be reunified with specific conditions in place.
That's correct, Your Honor. The conditions that we had listed out were really just to narrow down the contact to the children in this family. Otherwise, the remainder of the conditions would remain unaltered.
And I haven't had a chance to read over this. You have to follow this, correct?
No, Judge. In fact, we were just given a copy of it recently. I didn't necessarily want to make it part of the record either, because these were recommendations from the doctor. And I know that they have been doing counseling services through her voluntarily in sessions. They've had a couple of sessions with this doctor, which we requested at the last hearing, where we had to have a pass on that. We started that process with this doctor under the advice of the probation department. So been trying to do what the probation department also wants to see that.
That's any concern on the probation department with modifying this condition. And remind me, is the victim of this offense in the home, be in the home that would be reunited to?
No, Judge. And obviously there's no contact with the victim regardless of the modification. We understand that.
Sort of. Have you reviewed the plan and the things that Mr. Fuller.
So I talked to Mr. Clark as well. She's.
All right, then, the board is going to grant the defendant's motion to modify conditions of immediate supervision. For we have a modified set of conditions, or do we have an order that would make that revision? All right, Mr. Gould, so the board's gonna grant that, a wait for that to be printed and provided to the board. So if you'll just have a seat whenever she brings me that document, I'll sign it, we'll meet with her, we'll sign up for that.
And Judge, and the defendant would request as a footnote here that he would need to go up to Michigan, travel to Michigan to move the family back with their belongings. And so at some point, I believe he would seek permission to do that for that limited purpose to live this the county.
Yes, and he'll do that through the probation department, and as long as they authorize that, it is for that purpose, shouldn't be an issue.
Thank you, Judge.
Go ahead and have a seat, and Ms. Burns gets the paper, we're ready to, she'll come see you, have you sign it. I would excuse your office. Yes, thank you, Mr. Lord. Morning, screen.
Morning, Your Honor. How are you?
Good. Are you ready?
I am ready on Kirkland Huggins, Judge.
All right, Mr. Huggins, CR 2125. All right, this is hearing on Mr. Huggins' motion to adjudicate. Assuming that council, you'll need time to meet with Mr. Huggins. I think this is your first appearance in court with Mr. Huggins.
That's correct, Judge. And I did visit with Mr. Hartwell yesterday. We discussed the case a little bit, but the state also needs a little more time as well to decide how they want to proceed. Hopefully, we'll be able to reach some kind of agreement to present to the court.
What I can do is set it for one of the 3 dates for just a standard docket call, basically on the MTA. And then I would also set it for an evidentiary hearing at the same time, in case it's not resolved. But look at your calendar, it's something September 19th, 21st, 26th. One of those.
19th,
21st
to 26th.
Class.
Is the 19th or 16th? Is it a morning docket, Judge?
Oh, well, both of them will be morning dockets, all 3 of those, since he's on bail.
26th will be fine, Judge.
All right, so what I'm proposed to do is setting for basically an announcement on the MTA to see if we have an agreement. If we don't, but I'm also going to go ahead and setting for that following Thursday, which would be the
28th.
contested docket. So if there's no agreement by the 26th, we could have a contested hearing on the 28th.
Okay, Judge. Both of those, both at 9 a.m.
Yes, sir. All right, Mr. Huggins, we'll see you back on the 26th. Thank you.
Judge, I'm ready on Lisa's piece as well.
This piece, CR 22389. Lisa's piece, yes.
Just go, Judge.
All right, I show that we are set on, I believe it's motion to president.
It is, Judge.
Are you ready to go forward with that today, or do we need to reset that?
Judge, Mr. Hartwell filed a motion for continuance that I agreed to earlier in the week. So we just, subject to your approval, we'll just need a new date.
All right, well, we'll grant the motion for continuance and we'll set this matter on September 28th at 9 AM.
And that's all my business, Judge, my excuse.
Ms. Peace, you can be excused from screen. I'd like to see you. Who are you ready on? Mr. Estridge. CR 11-119. Yeah, I'm just under. May we approach? Yes. First of all. All right, we are back on record, call number CR 11-19, versus Jeremy Estridge. Mr. Estridge, a motion to, adjudicate, I believe it's been filed. And, there's an agreement between the parties, and what I'm gonna do is I'm going to reset your case. And the purpose of that is to allow you time to get into compliance by paying your restitution, okay? That seems to be the only issue holding you up. So the motion is still pending, right? You're still on probation. You still have to report, follow their direction, protest, follow those things. I'm gonna set your court date out a little bit further. The reason I'm gonna do that is because, one, you've been in compliance up to this point, all right, as far as forward. So I trust that you're gonna be doing what you're supposed to be doing outside of paying your restitution to the probation department. So I'm gonna set you in December. So this is August, just because we go from August to December doesn't mean you don't have to check in, pay your monthly fees and all those things, okay? Yes, sir. And I'm gonna reset you until December 12th. December 12th, we'll set for a status, and all I'm gonna be looking for is, are you still in compliance? Are you still making a state effort to discharge this restitution? The money that you owe, if you are, then we'll reset for another status compliance hearing. I'm gonna continue like that, online manner, until we decide on what's okay. In hopes that we can get you to a point where you can be discharged from probation. Okay? Thank you. You're welcome.
Robert Wales.
Robert Wells, CR 17-266.
Yes, sir.
All right, we're on the record, CR 17-266, State versus Robert Michael Wells. Mr. Webb, we set a date for contested hearing. I believe that there's agreement between the state and you and Mr. Schmidt to reset this matter to allow you time to try to get caught up on some of your fees and community service. I'm gonna grant the request to continue the case. I'm gonna reset you to October 26th. That's gonna be another contested docket date. So you're gonna be given 2 months to see what kind of headway you've made on your fees and your community service. Better you do, better news you'll get on the 26th. Worse you do, worse news you're gonna get on the 26th. All right. All right, once you sign and get the yellow copy, pretty good. Is William Lynn Petty here? William Lynn Petty. Is that all you got, Mr. Schmidt? Yes, it's one. All right, thank you, sir. He contacted this morning. He's not paid, he's not making it. Mr. Waddell said that Mr. Petty contacted them this morning and indicated he would not be, I don't know, today. We're making.
I think it's Livers Act on basically this thing. I don't know. I don't know if it's valid, if it is, but.
Okay. Please. Is Leon Baker here? Come on up, Mr. Baker. Mr. Baker, your attorney, Mr. Adams, is ill today. He contacted the board, said he could not be here. And so Mr. Adams had filed a motion to suppress. The state had filed a motion to deny that. The court has denied the motion to suppress at this time. So what I'm going to do today is just reset you for another court hearing, and that will allow Mr. Adams time to respond to the court's order and also give you recess so you can be here. Okay. Remind me, do you live out of state or where do you live? Fort Worth? All right, you'll just sign this, we'll give you a yellow copy, it just says reset date is September 26th. And you have his contact information, correct? You have his information, Mr. Adams, okay, so you contact him after for today or sometime this week, okay? Ready? Who are you ready on?
Judge, I don't coach on this four.
All right, this is file number CR 19-64, State versus Sinidra Janae Porter. Board has set today motion to adjudicate for Ms. Porter. Ms. Porter is my understanding that there's an agreement between you and the state wherein you want to have the court reset you to October to give you a chance to come into compliance with your community supervision. Right now, the probation department and state are supportive of that to try to give you another chance and take care of that matter. So I'm gonna reset you until October 12th. That'll be at 9 a.m. And on that day, I'll be looking to hear good news about whether or not you're complying. Fees, community service, all those things, okay? So the better you do between now and then, the better it's gonna be on the score, okay? That's what you sign, you the old copy, you're free to go. Next, Mr.
Judge, ready on Mr. Sean Davis.
Mr. Davis. This is CR 23-95. Pretrial.
Judge, yes, if you'll note, we were reset from last pretrial due to waiting on the status of discovery. In my conversation with the state this morning, they have still not received any updates from the sheriff's office regarding the status of that forensic discovery. And so we request for an additional pretrial.
Yes, sir, and I still haven't received the results of any phone dumps. I haven't personally been in contact with the sheriff's department, so I don't have an estimated time. If the court would like, I can try and reach out and get a estimation for you.
And Judge, at last reset, when I asked the investigator Keltner, who's handling this case, forensic dump, he told me it would be 2 to 3 months from that time point. I believe that was 1 month ago. So it may be another month or two before he has something definitive for us. Additionally, Judge, as this is a outright statement from an adult from 10 years ago, it's gonna take that forensic evidence is very important for this case, and so we request reset for that to be distributed both to the state and to the defense.
All right, court will set Mr. Davis for an additional pretrial hearing on October 12th. State can, in the meantime, talk with the investigator, find out, have a more definitive deadline on when that discovery to be available and provided to the defense.
Yes, Your Honor.
All right, Mr. Davis, would you sign it to go inside? Who else was waiting?
Judge, Miss Andrea Pullins.
Andrea Pooling, CR 21-140. First,
Judge, in speaking to Ms. Pullings, she is still attempting to be in compliance with the conditions of probation. She's had some difficulty over the last few weeks getting in compliance. I had a conversation with her last week discussing her situation. We asked for an additional reset, give her one more reset, a short reset to try to get some of those issues resolved on her end.
State agrees with an additional reset, Your Honor.
all right, court will reset Ms. Pullings to October 12th. For compliance hearing.
Judge, I thought I was. Control.
All right, this is file number CR 21-403-406. State versus Kate Providence Mitchell on the motions to revoke. Go ahead, Mr. King.
Yes, Judge, there's a new offense alleged in the motion to revoke. And I believe we're waiting on discovery or have recently received the discovery for the DWI. I have not had an opportunity to go over that with my client, so I request recess to discuss our options for the motion. Additionally, we have not had an offer made yet by the state to resolve this motion to revoke.
Earl, do you know if the state intends making kind of offers in this case to Mr. Mitchell?
I believe so, Your Honor. I'm double checking now to make sure that discovery is being sent. And I expect we'll have a conversation with Mr. Manning about a potential offer.
So, Mr. Manning, there's a motion to revoke on prohibited substance felony. A motion to revoke on driving while intoxicated second, but you're saying that there's a new offense alleged inside those motions.
Correct.
That's a DWI, you said.
I believe so. I mean, yes, Judge.
Is it a Van County DWI?
I'm not sure. I believe, no, my notes say that it is located in Montgomery County.
Okay, so. All right, so the board will grant Mr. Mitchell a reset on both motions to vote to October 26th. That'll be a contested hearing on that date. Be back on 10/26.
Judge, with the exception of Mr. Young, I believe that concludes my business. I have not been in touch with Mr. Young since he was released from the jail. I do understand that Mr. Young, one of the reasons he was released was he did have a serious cancer diagnosis that he was received treatment for once he was released. But I have not been in touch with him since that point in time.
Okay. Let me check something on this case. Formal and his name called. Oh, yeah.
Judge, I'll see you this afternoon.
You. All right, we're on record, CR 23-70, state versus agreement, you're set for evidentiary hearing today. Go ahead, Mr. Flynn.
Your Honor, we're gonna ask the court, I think the state is in agreement. We're gonna ask the court to reset this for an evidentiary on October the 26th.
Objection, state.
No objection, Your Honor.
Right, court will set this for hearing on evidentiary. Motion to suppress October 26th at 9 AM.
And Your Honor, Mr. Hughes' son is here. He's fluent in their language. And I'm gonna ask the court for a short moment to step out and explain, make sure that everybody knows what they were supposed to do.
Ready on Mr. Gonzalez. Mr. Gonzalez. Come on up. This is cause number CR 22-135, state versus Trent Manor Gonzalez. It's motion stress.
It's
You have a big one.
I don't know. I don't know this thing.
All right, Mr. Gonzalez, you'll raise your right hand, place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Your name is Trent Matthew Gonzalez, is that correct?
Yes, sir.
Mr. Gonzalez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the representation he's given you?
Yes, sir.
Feel like you've had enough time to talk with him about the case, and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
I understand it all, sir.
Mr. White, do you believe Mr. Gonzalez is competent? If so, have you explained to him his rights as it pertains to this case, including the advantages and disadvantages of the deferred adjudication plea?
Your Honor, I Gonzalez, advantages of jurisdiction. Satisfied with the as what actually required advantages that I get from it. Please, also with these waivers rights.
Thank you, sir. All right, Mr. Gonzalez, you are charged by indictment with a state jail felony offense of possession of controlled substance, felony for 2, less than 1 gram. That does carry a range of punishment that if you were convicted and sentenced could include confinement not less than 6 months or more than 2 years in a state jail facility of Texas Department of Criminal Justice. And it could also carry a possible fine of up to not to exceed $10,000. I see that the plea agreement in your case is that the state's recommending that the court defer a finding of guilt at this time and place you on community supervision for 3 years. Order you to pay a $1,500 fine plus court costs and reimbursement fees. Mr. Gonzalez, is that your understanding of the agreement?
Yes, sir.
That's what you're asking the court to approve.
Yes, sir.
All right, Mr. Gonzalez, then understanding the range of punishment and also the plea agreement, at this time, I would ask you, how do you plead to possession of controlled substance, milligram 2 less than 1 gram?
Well, I screwed up.
Well, do you plead guilty or not guilty?
Guilty.
Guilty.
Yes, sir.
And are you pleading guilty to that crime because you committed that crime?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence? No objection. All right, that is admitted to evidence. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, sir.
Court's reviewing the stipulation of evidence at this time. All right, based on the evidence before the court finds that there is sufficient evidence to convict Mr. Gonzalez of this offense, the court will follow the plea agreement reached between the state and the defense. The court defers the finding of guilt, places Mr. Gonzalez on 3 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $35 reimbursement. Mr. White, can I have Mr. Gonzalez sign this certificate of discovery? All right, Mr. Gonzalez, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come over here to be fingerprinted with Deputy Martinez. The probation officer to say about the next steps, okay?
Yes, sir.
Bless you. Right, let the record reflects that James Paul Young, William Lynn Petty did not appear in court today. Their names were called out distinctly 3 times in the courthouse with no response. According hereby issues the judge's pass and for the. That concludes the morning. Docket, and then we'll resume that. It's gonna recess till that.